नमस्कार, मैं राजेश शिंदे VOA इंडिया में आपका स्वागत है। पिछले महीने जो एक केस हुई आरजीकर अस्पताल में, उसके बाद बहुत आक्रोश है और उसके बाद सोमवार को वेस्ट बंगाल में, पश्चिम बंगाल में विधानसभा में एक सत्र बुलाया गया और एक एंटी रेप बिल उसको पेश किया गया और वो पास किया गया। इस बिल के बारे में बात करने के लिए हम आए हैं झुमा सेन जी के ऑफिस में। उनसे, वो एडवोकेट हैं, कलकत्ता हाई कोर्ट में वो प्रैक्टिस करती हैं, सुप्रीम कोर्ट में वो प्रैक्टिस करती हैं, यूएस की ब्राउन यूनिवर्सिटी की वो सेंटर फॉर ह्यूमन राइट्स एंड ह्यूमैनिटेरियन स्टडीज़ में वो ग्लोबल फेलो हैं। वो बहुत सारे अखबारों में लिखती हैं और वो लॉ कॉलेज में भी पढ़ाती हैं। तो पहला सवाल मैम मैं आपसे ये करूँगा कि ये अपराजिता बिल ये है क्या और इसमें क्या क्या प्रावधान?
It is an unthinking bill. It is not a bill which has been made with the purpose of protecting woman and child, because it is called APARAJITA Woman and Child Criminal Law Amendment Bill 2024. The changes are broadly in three arenas. First is the sentencing. So the sentence has been made, the punishment has been made harsher. So admittedly more stringent, harsh punishment. This is 80% of the bill. It makes this, it brings these changes in offences of sexual violence, in rape cases, in certain kinds of rape cases, in POCSO cases, and also in acid attack and certain kinds of other cases. Now, the other two parts, where the changes have been affected is one, the bill aims to create a cadre of special courts and appoint special public prosecutors. And the third one is, it aims to create what is known a special task force. It calls it Aparajita task force. On pen and paper, we want to ensure that such incidents do not occur. So we tend to think in terms of this, that harsher punishment equates with justice. But it is, let me tell you and let me be very honest about this, it is not so. What happened in Nirbhaya? Nirbhaya was also, in 2012, there was a bus rape. A brutal rape inside a moving vehicle, a moving bus. It was a gang rape, and she was also a student, a physiotherapy student, and she did not survive. And there was a huge protest, which is reminiscent of what is going on right now. So after that incident, the protests were taking place on the street. There was something called the Justice Verma Committee. The state set up a committee. This was in Delhi. The aim and purpose of that committee was to recommend changes to criminal law and in matters of sexual violence. It was meant to provide for and prescribe, look at arenas of sentencing, arenas of punishment. But what it ended up in doing, thankfully, is that it engaged in a very, very deliberative process, very extremely consultative process, where all groups, women's groups, feminist groups, everyone came before the committee and submitted, they deliberated. And this question on harsher punishment, on death penalty, came up at that point of time. The Verma committee submitted a big fat report, and it submitted recommendations where it did not recommend death penalty. Why? Because feminist groups did not want death penalty, and there is a certain wisdom to not wanting death penalty, because you see what happens is death penalty is not a deterrent. It's a retributive sort of punishment. There is ample studies across the globe that it is not a deterrent, and it recommended that there should not be death penalty. And even though it did not recommend, the state, after the recommendations were submitted, the state took some of the recommendations of the Verma committee. State ignored quite a few, most of its recommendations, very progressive recommendations. For example, removal of the marital rape exemption, because rape within marriage is not a crime in this country even now. So the Verma committee had recommended that it should be taken off. But those suggestions and recommendations were not taken into account, and the state some of the legislature brought in its own other the changes that it wanted, and it the legislature in its wisdom removed discretion in rape sentencing. So in 2013, the bill that was passed, the Criminal Law Amendment Bill 2013, that removed, so punishment at that point of time, the punishment, before that the punishment was 7 years, but there was a discretion on the judge to award a lesser punishment. That discretion was removed. It meant that it became a little harsher. So there was a mandatory minimum of 7 years punishment. In 2018, the law changed again. The 7 years mandatory minimum 7 years became mandatory minimum 10 years. And this was also in reference to in response and in reaction to another brutal rape. So what happens? All this over the years we have seen that the punishment has increased progressively. But has it stopped the offense of the crime of rape from happening? It hasn't. What has happened? The conviction rate has gone down. Why acquittals result? And that is because the conviction rate comes down because once the punishment is increased, the quantum of punishment is increased once it becomes a harsher punishment. The standard of judicial scrutiny also becomes very, very stringent. So the threshold that has to be met is really a high threshold. So when that happens, of course, in our country, the investigation is usually very shoddy. And victims turn hostile, witnesses turn hostile. Why do victims turn hostile? Because there's a lot of victimization, double victimization inside the court. Now the mandatory minimum punishment, so the erstwhile 10 years punishment, mandatory minimum punishment has now been made a mandatory minimum punishment of life imprisonment for rape, where life means the remainder of one person's natural life. So this is significantly harsh. So you can quite well imagine that when the conviction rate and there are some studies after the 2013 amendment which has demonstrated how conviction rates have gone down after the 2013 amendment because of mandatory minimum punishment. And if one looks at then and if it looks at now, so if with mandatory minimum 10 years punishment conviction rates coming down, one can very well imagine what it is going to do to conviction rates with where the mandatory minimum is life imprisonment, where life means the remainder of one person's natural life. And this is not just the only punishment that has been increased. Most significantly, and this is, I cannot stress that how, in how cavalierly this has been introduced, there has been a mandatory minimum punishment prescribed for death, which is a death penalty, for rape which results in death or persistent vegetative state of the victim, which is an amendment which came in after Nirbhaya. But that did not, death penalty there was one of the options. It was not the death penalty was introduced, it was not the only option. Now what has happened here is that this APARAJITA bill has made mandatory minimum punishment of death penalty. Now this has been introduced in like I was saying, in a very unthinking fashion, without even doing, I cannot believe that any lawyer has, I do not actually think this has been drafted by a lawyer, because any lawyer, any legislator would know that this is unconstitutional. There is in 1980, early 1980, there's a Supreme Court judgment, it's a constitutional bench judgment, very widely known, Mithu versus State, where the Supreme Court categorically stated, and it's a very well reasoned, on very sound principles this was stated, that mandatory minimum punishment of death penalty is unconstitutional. And this is globally, if one looks at the few jurisdictions which retain death penalty, even in those jurisdictions, mandatory minimum death penalty is usually not kept as a form of punishment, because death penalty in itself is not a deterrent, it is a retributive form of punishment. It is considered as an inhuman and degrading form of punishment. It is, and there is absolutely no proof anywhere that connects death penalty with reduction in the rape. So when most acts of rapes are committed by known persons, if the mandatory minimum punishment is a death penalty or an imprisonment for life, where life means the remainder of one person's natural life, then anyone can imagine what it means, what it means to reporting. As it is, we have very, very less reporting of rape, and that is owing to a number of factors. It's owing to the shame and stigma attached to rape. There is very little social support system. There is a certain kind of conditioning that occurs at home. Women are discouraged. So reporting of rape in any case is very low, significantly low. And when you sort of think about that, when you club that with the fact that rape is mostly by acquaintances, by known people, by family members, and then you have something like a mandatory minimum death penalty, it becomes a very complex situation for the victim. There are two other things which the law, which this bill seeks to do. One is it brings in this special courts, and like I said, that special courts on pen and paper, it's a brilliant idea. Special courts there must be something very special to it, but let me tell you that special courts are very general. Without the hard work of making the institution of special court functional, and that is actually hard work. You need gender sensitization, you need training, you need budgetary allocation, you need creating that kind of infrastructure that really makes a special court special to make it really work. There are special public prosecutors have been prescribed as part of this special courts, and we know how our POCSO courts and special public prosecutors in POCSO courts are functioning. They are overburdened. There's a huge pendency of cases. There are very little number of public prosecutors, even the special public prosecutors who are appointed. Many of these appointments are also very political appointments. The right kind of training is absolutely amiss. Last bit that it tries to do is creating this special task force. Again, on pen and paper, it is amazing, but the special task force is really, it's your police. It says that the special task force is supposed to be headed by a woman, but just having a woman at the top heading a special task force does not necessarily mean that it is going to be extremely functional. So a special task force, this APARAJITA task force, it is not clear about the nature of the special task force, and there is no budgetary allocation anywhere. In fact, the bill says that it does not require any additional funds, but there is no budgetary allocation. So who is going to have these special task force and these special courts properly functional unless these are adequately made functional, unless there is a political will to make these necessary changes in the infrastructure and so on? I don't see that much is going to change.